So David Katz, a former assistant U.S. attorney, and joins us now. He'll have headphones next week, but it's so cool that you joined us on Tuesday. This is the spot that was occupied regularly by Pulitzer winner David K. Johnson, who's away for the moment. He'll be back in about 6 weeks. But we want to keep you because we adore you. And the Supreme Court is front and center today. First of all, I want to just quickly mention what I was talking about the first hour, which is, I guess they've given cover to Donald Trump in the tax returns. Can you weigh in on that, please, David Katz?
Sure. Let me just make sure that you folks can hear me. You can, fine?
Yes. Yeah.
Great. Okay.
Go ahead.
Well, thank you. I had an assistant helping me, but it sounds like the sound is coming through okay. So thank you very much. Thank you very much. Well, yes, they have given cover to the Supreme Court today. The Supreme Court has given cover to Trump. And it's normal that they would delay for about a week or 10 days. That's what Chief Justice Roberts has done, so that Trump's team or the Justice Department, I guess the Justice Department, can file a response. I'm sure the Justice Department will file it very promptly. But then the big question is going to be, does the Supreme Court rule on it after they've had the response from the Justice Department very timely? Because Trump is trying to run out the clock. And if the House goes over to the Republicans will simply withdraw the subpoena. Now, people may be surprised, how does that work? There's a statute which says that the Tax Writing Committee of the House Ways and Means Committee, that its chairperson has the right to ask for the tax return of anyone in America as part of the oversight duty, as part of the tax code drafting duties of the Ways and Means Committee. The chairperson can ask for that, and the chairperson does. But if they control the House, they'll also control who's the head of the House Ways and Means Committee. So once the Republicans put a new head in there, that new head will withdraw that request for Trump's tax returns, and he will have run out the clock if the House goes Republican. And so the only way to stop that is for the U.S. Supreme Court to put on its big boy pants, its big girl pants, and to say he's running out the clock again. The federal district court ruled against him. The federal appellate court ruled against him. And he's only trying to run out the clock until maybe January 3rd, when there'll be a new Republican head of the House Ways and Means Committee. And he will have gotten away with never turning over his tax returns. That's what he's aiming for. And let's hope that there are 6 justices on the Supreme Court who, Republicans or not, 3 of them appointed by Trump or not, are not going to let them be played in this way that will just disparage all respect that people might still have for the U.S. Supreme Court, because he will have just played them in a way that no litigant should be able to play the Supreme Court, especially not a former president of the United States, throwing his weight around and it looking to the public like, well, he appointed 3 of them, so he got his way from those 3 and another couple of conservatives. And so all they have to do is not decide. There'll be nothing left to decide, Mark, if the Republicans take the House after January 3rd. They'll withdraw the request. And no, it can't go over to the Senate, even if the Senate stays Democratic, because it's a particular power in the chairperson of the House Ways and Means Committee. I don't believe that the statute gives that power to the head of the Senate Finance Committee.
Yeah, it's an odd fact, but that's exactly, David is so right about this. They're sort of very specific things that the Senate can do and the House can do. And this is one of these specific things the House can do. I'm wondering if what you're talking about, the stalling tactics, which we were all very familiar with from the Trump organization, which they've used so effectively, it's an unholy strategy, but it has been effective. I'm wondering if you feel as though this strategy, which has likely been employed on the side in terms of dealing with the Justice Department, I'm talking about with Merrick Garland's crew, whether you feel that also might carry the day. So the Republicans win the House. I mean, again, that would then change the arithmetic on this, and he'd no longer have to submit those tax returns. But the Justice Department, unrelated to all these investigations, unrelated to Congress, these are charges that will come out of the Justice Department. I'm wondering if you could handicap, in essence, that strategy as it might relate to some of that coming out of the Justice Department.
Let me just digress with one example of how Trump has run out the clock. If you remember, one of the people who was trying to get a hold of his tax returns was the DA in New York City. He ran out the clock. That DA had some very diligent staff, you'll recall, who went all the way to the U.S. Supreme Court. They did a great job. They beat Trump like a drum twice in the U.S. Supreme Court. And by the time they finally got the tax returns, the New York City DA, that DA had left office. The new DA, I guess, is worried about street crime or other things that a DA needs to be worried about. And the DA, remember, is not proceeding with that criminal investigation that his predecessor would have probably proceeded with, would have indicted Trump had he had the tax returns. But in that instance, Trump got away with it, running out the clock, even though the DA won twice in the U.S. Supreme Court. But it took 2 years, and the term of that DA then ended. Now, regarding can I get back to your question, Mark? I'm sorry, I just wanted to get that in.
No, of course, that's great. So I was just asking about his in relation to the Justice Department and what we feel sort of imminent Garland charges that will come out of the Justice Department toward the Trump organization. I wonder if you could handicap for us how this strategy of delaying or what other strategies legally he might employ in dealing with that.
Well, I mean, if the House and the Senate go overwhelmingly Republican, that doesn't, of course, end the tenure of the Attorney General. Merrick Garland will still be in office, but there's all kinds of ways that they can harass the Department of Justice, try to blow back at the Department of Justice. So everyone who cares, I think, about the rule of law and what's going to happen with this Trump investigation really needs to get out and vote. It's just a week away, and boy, do elections matter. We're going to talk about the affirmative action decision too, and of course there was Dobbs that overruled Roe v. Wade, and that was years of Republicans getting out the vote. That was the evangelicals and the other ones getting out the vote, election after election. And before you know it, they control the U.S. Supreme Court 6-3. And it was woe to Roe v. Wade. And I think it's going to be woe to affirmative action as we've understood it in the colleges and universities. And then from there, maybe in the high schools, especially the selective high schools. But I just think that the Department of Justice won't have any trouble getting the tax returns. I was an assistant U.S. attorney, and if it's relevant to a criminal investigation, there's a form that you fill out, and the IRS has to turn over the tax returns. So I think months ago, Merrick Garland has gotten all of Trump's tax returns, and I'm sure they are really eye-opening, both eyes wide open, because you remember there was one sheet that leaked, and from the one page of 1 year of taxes of Trump, he'd lost more money, I think, than anyone else in American history. He wasn't America's biggest winner. Trump was America's biggest loser. And yet his base looks at him like he's some kind of financial wizard. He was America's biggest loser. He lost $100 million, at least according to him, and the tax return that he must have signed under penalty of perjury. He lost $100 million in 1 year. And so if the tax returns ever come out, they're going to be incredibly embarrassing. It won't leak through the grand jury process because that would actually be a crime and no one should leak them. But at some point, Trump, I do believe, is going to be indicted. I believe there's going to be some tax charges, and I believe that his tax records will become public. And the people who are already stunned by how this man could have ever been president or held himself out as a financial guru are going to be even more stunned than we already are.
Yeah, I fear that, from the standpoint of electability, there's a weird kind of bulletproof quality that Trump has, and his reputation, which I think could be sullied in so many different ways. He's beholden to foreign interests. He's been compromised and has a pay-to-play corruption side that I think has been manifest in his last administration. He did get rich after he became president. I mean, it seems like all the money came in, and now he's set up, as you know, this a PAC, a super PAC, effectively, that can siphon off money into all of these different Trump expenditures. In fact, that's where it's going. It's not going into any kind of re-election, exploratory anything. In tracking that money, I think Farenthold at the Washington Post did a really good job of tracking where that money was, at least the money that he could follow. And it was going toward these things that would personally enrich Trump, as opposed to being any kind of political donation to other Republicans and this kind of thing, as was stated in the original fundraiser. Now, to the Supreme Court and affirmative action. So they're hearing this case. It involves Harvard and North Carolina. Bring us up to speed, and I wonder if you could just kind of frame its significance. You hinted at it. I mean, it cuts beyond just universities and colleges, I guess.
Well, it's deja vu all over again, especially for me, because I was a law student. Then it was called Boalt Hall, now Berkeley Law, at the time that Bakke was taking place. Bakke versus the University of California, the Regents. And many of the law professors that I had in class were writing the briefs for the University of California, because Bakke had tried to get into the medical school at the University of California at Davis. And so he was the plaintiff, and the university that I was going to law school at was the defendant, or the university system was the defendant in the case. Through some procedural oddities that I won't get into, I believe Bakke eventually got a stay, and he himself became a doctor. But the case remained ripe, and it went up to the U.S. Supreme Court, and there was a 4-4 tie, basically, whether what some detractors call reverse discrimination, what has had the name since JFK and LBJ as affirmative action, was proper. Whether this was discrimination, no matter how good its goals were, was this discrimination or not? 4 of the justices were prepared to say that it was discrimination against the white applicants who couldn't get in. 4 of them were prepared to say that it was affirmative action, that it was necessary to rectify past discrimination, to sort of even the playing field. It was needed at least for a while. The swing vote was Justice Powell, and Justice Powell said that even though discrimination is obviously a very bad thing as a principle, the countervailing principle is the need for diversity. And so, we now have the word diversity bandied about. There's what some people who are detractors call the diversity industrial complex. There's all these like quips and snide remarks made all over this very contentious issue. But Powell's vote was decisive. And so diversity is what we're looking for. And then there's all of these arguments since then, including there was this famous Texas case 19 years ago, which basically allowed the kind of affirmative action that the University of Texas, I believe it was at the law school, had. Other interesting things for your listeners and viewers is that we had a referendum, a statewide initiative in this state that actually banned affirmative action, the use of affirmative action in the professional schools. So medical school, dental school, other professional schools, it was barred. The voters actually voted against it, which was very surprising, of course, to some people. It's a very hot, contentious issue. It's also an issue, of course, among Asian Americans. And in fact, Asian American students are the ones bringing the present case to the U.S. Supreme Court, or an organization of Asian American students, because the impact, and this is what Alito says, it's a zero-sum game. The impact has been certainly, year after year recently, detrimental to Asian Americans as a group, because if there's 100 places and 10 are, the goal of the university is to fill 10 of them, let's say, with African Americans, and another, let's say, 10 of them with Hispanic Americans and Native Americans. And then you see in the same year that many Asian Americans are denied admission to the school. And then the question was in the U.S. Supreme Court, Mark, what is this diversity? And so people like Thomas act like they don't even know what diversity is. They don't understand it. He's diverse. He's an African American who's adamantly against affirmative action, although he was himself, don't kid yourself, the beneficiary of affirmative action to get where he is today. But he's certainly diverse in his opinion. Is that the kind of diversity they're talking about? In my opinion, this should be a remedy for past discrimination. There's a reason for, as Justice Kagan, one of the moderates, liberals, one of the 3, as she said, for people who've been kicked in the teeth by society for not just decades, but generations and centuries under slavery, there is a compelling reason to give a leg up, a break. And so if the class would have been 3 out of 100 African Americans, and these goals and these programs end up being 8, that's a laudable goal, and it's one that is not reverse discrimination, but it's an appropriate remedy. But of course, the people in the zero-sum game of admission, when there are 100 places, the people who didn't get the 5 places because there were 8 African Americans and not 3 are complaining. And I think they're going to win in the U.S. Supreme Court on this issue, and they're going to find that diversity is not compelling. They're also going to say that we've tried it all these years since Bakke. We've tried it for 19 years since the Texas case, Justice O'Connor joining the people who would have kept affirmative action in place, who did keep affirmative action in place in the universities, said, we need to try this for another 25 years. We can't be doing this forever. It does become discrimination at some point, whether reverse or not, it becomes discrimination. But 25 years, it should be about 25 years. Well, now it's 19 years. So you have all these questions like by Alito, which says, tell me, Harvard, when are you going to stop this program? When are you going to have done enough? And of course, Harvard didn't want to answer the question, because think about it, Mark, how would you answer the question? And the answer may be that it will, be used less as time goes on, but it will still be used. And if the Supreme Court rules the way I think it will, and they say that diversity is not a compelling goal, and that these two programs at Harvard and the University of North Carolina are not valid, that's not the end. They'll come up with new programs at all these universities, and the question will be whether they pass muster. They may do things like give an add-on to people with low socioeconomic backgrounds, people who came up the hard way, people who came up from poverty. But there's more people statistically who are white, who came up the hard way, came up through poverty, are in Appalachia, are in slums, are all over the place, than there are blacks and Hispanics. And so statistically, you don't get the effect of helping the groups that you're trying to. You also have the anomalies that people always point out, like Reagan used to talk about the welfare Cadillac recipient, the welfare recipient who drove a Cadillac. There might have been 5, but of course, that's all he wanted to talk about. They talk about the person who's African-American, whose dad was a diplomat, and who ends up getting into some school over affirmative action. And then they give you the other side, some poor guy who, grew up, above the elevated subway. His parents worked around the clock. And that example that they give on the other side is often Asian. In New York City, you look at the Asian Americans who say that they are having a really hard time getting admitted despite their merit and their hard work. In New York City, specialized high schools at these universities like Harvard. They're not all people who came over from Asia with a lot of money and studied here. They're really working class. Their parents have really busted their behinds to help their kids. And they say, well, now they're getting a special advantage, Mark, because they have these tutorials, they get extra tutorials. But, if extra tutorials are so helpful, let's get them in the poorer schools. Let's get them in the minority schools. Maybe we need to teach to the test, right? Maybe we need to teach to the test in those things, so there is less of an advantage, because I totally support the goals of affirmative action. I actually was a law clerk to an African-American judge. In his particular case, I don't think he got any advantages from that system. He came up through the Army and the JAG Corps. He got hired by Bobby Kennedy before there ever was affirmative action at the Department of Justice. He was a person who, by any standards, came up through his merits. But he was a supporter of affirmative action before he passed away. I'm a supporter of affirmative action, but I think this particular case, Mark, I think they're going to rule probably 6-3. Chief Justice Roberts has been an opponent of affirmative action for quite a while. He has a famous quote: I think the way that we should stop discrimination on the basis of race is to stop discriminating on the basis of race. So I think he's a lost vote. I think Harvard and the University of North Carolina are both going to have their programs struck down probably next May or June. They always hold the hot ones to the end, right?
And your suggestion is that there'll be other programs to replace these. So diversity, and because we're also talking about diversity. It's not just, who can get in. It's the consistency and texture of your students and the kind of environment that these schools are trying to build. They're trying to build not just a lily white environment, but typically, at least in the case of many of these universities and colleges, they're trying to build a cross section. They're trying to build an environment in which students can be exposed to different cultures and different people and different races and different ethnicities and religions, this kind of thing. It would seem to me a healthy educational environment. Are you suggesting that other programs, I think you had kind of alluded to that earlier, might come into play such that they'll still be able to achieve some of those diversity goals?
Well, yes. I don't think that the universities who feel very strongly about this, as I do, as being a laudable goal, will try to achieve it some other way. Like I said, the Supreme Court has suggested some in their questioning on Monday. Some of the conservative justices said, well, why don't you use a socioeconomic test? And as I say, the problem with a socioeconomic test. Yes, you get a certain kind of diversity. That's certainly true. I think the schools try to get that. I think if you're a poor white kid from Appalachia who's really come up by his or her bootstraps, I think they want you in that school. If you've got, let's say, military service, if you speak 2 or 3 languages, if there's something, really unusual, if you're disabled now, for a while under diversity, they were, maybe they still are, if you're LGBTQ, right? All kinds of diversity. And of course the schools want that, but I think trying to get it the way they've been trying to get it, with anything that looks like an add-on for being a Black, Hispanic, or Native American, I think is going to be more suspect in the future programs. I think socioeconomic doesn't really get you the goal of increasing as much as these schools would like to, the Black, Hispanic, and Native American component, number of students in the school. And I think that, they said some questions. I thought they were kidding, where they said, well, if they got rid of the legacy admissions, if they got rid of some of these set-asides for donors, come on. These private universities are not going to get rid of set-asides for donors' kids, and they're not going to get rid of legacy admissions. Who are we kidding? That's not, yes, you would have less white people. They're probably predominantly white people who get in on that basis. One thing that was interesting about Bakke and the 100 places at the medical school back in the late 70s, 10 were set aside for doctors' kids, 10 were set aside for state legislators' kids here in California. And Bakke didn't challenge either one of those because he didn't have a good equal protection challenge. He figured his best equal protection challenge was that he was not allowed to get in. And he was very close. He knew that but for, let's say, 5 or 10 minority admissions, he would have gotten in. I think that's why ultimately he got his stay that allowed him to start his education and complete his education. But I just think that from everything they said at the oral argument, it's going to be 6-3 to strike down these particular programs, and obviously the new programs may be less diverse. And it'll trickle down from there, I think, into the high schools. I went to a specialized high school in New York. I had to pass a test for it called Bronx High School of Science, and it's been very controversial. The fact that it has a much higher percentage of white students and Asian students than it does Black and minority students. But I'll say this, before they ever had affirmative action, 2 of the kids who got in from my junior high school, as it was called then, were African American. And one of them is a very successful attorney here in Los Angeles. So 2 out of 4 were African American, and this is in the 60s. So there's an awful lot of achievement. These people who go around and think that somehow it's disparaging. That's one of Thomas's arguments and some of the other conservatives' arguments, that it's sort of a badge that you didn't do as well. Let's see Obama's grades, that sort of thing. By the way, you don't see people going around with placards when Justice Thomas is speaking. Let's see Thomas's grades. It got him into Yale Law School. Let's see Thomas's grades. You don't see placards like that. As I said, there's an awful lot of bad blood over this issue. There really is. This one is a really contentious one, and it's going to be ugly after they rule.
But this now newly heavily weighted court, it seems the outcome is predictable. So much love for you on the chat, David. I wish we had more time to talk. You are a great asset to our show. We'll work out the audio, although the audio worked out with John. John just had to herd over the mute a little bit, but we'll get you, headphones for next to our headset, and plug in. But the picture was great. You sounded great. But more than anything, I just want you to know a massive contribution to our show. And I really appreciate you being here.
Mark, it's great to be on with you. If I can mention one last thing, I spoke at the Law Library over the weekend, and I gave your show a plug. So I hope people are joining from the Law Library.
Yeah. I love that. Well, I thank you, Dave. You can reach David. We have it. We've been up with the conversation, the super with your name on it, at David Katz Law on Twitter. David Katz, a former assistant U.S. attorney. Such a great resource. Thanks for the plug to the high-end lawyers, too. David Katz, everybody. Thanks, David.